when you have a statute that's about men and women being equal in the workplace, and you're dealing with a very real physical difference between men and women, what does equality look like? Does it mean treating men and women exactly the same, men and pregnant women exactly the same as if pregnancy weren't in the picture? Or does it mean taking account of pregnancy? And that's caused at one point, I mean, it still has lingering effects today, but at one point that caused a very serious rift in the feminist community that's covered in Chapter 5, the Cal-Fed case. But in the early years after Title VII was enacted, courts and the EEOC did not know what to do about pregnancy. They were so confused. The EEOC finally in 1972 issued a guidance, the law was enacted 64, issued a guidance in 72 saying, okay, firing someone because she's pregnant is illegal. Erasing her seniority while she's out on leave having a baby, that's illegal. And the Supreme Court also had a decision about that. Those kinds of punitive measures. There was another case that went to the Supreme Court about a woman who was a teacher who her school district enacted a rule that after the third or fourth month of pregnancy, the teacher had to be out of the classroom because she had to be on leave. She couldn't be anywhere near the kids. So those kinds of restrictions were struck down, but where the court really got gummed up was when it came to things like should pregnant women be able to participate equally in a paid disability leave program that they had in place for everybody. So the guy who's out for a while getting cancer treatment, the woman who's out for a while having her baby, he was getting a paycheck and she wasn't. That was at General Electric. And that went up to the Supreme Court, and the Supreme Court actually found in General Electric's favor. They found that pregnancy discrimination wasn't automatically sex discrimination because there were plenty of women who never got pregnant. So this wasn't a distinction between men and women. This was a distinction between pregnant and non-pregnant persons. The backlash was swift, and Congress enacted the Pregnancy Discrimination Act in 1978. The General Electric decision was in 76. And the PDA definitely cleared things up to an extent. But the two cases that are in the book about pregnancy, well, three cases that are in the book about pregnancy, all are after the PDA. So it should show you it didn't quite clear everything up.